If you're trying to get attorney referrals in probate and you're not getting calls back, it's not because attorneys are busy and it's not because they didn't like you. It's because they've already evaluated you and decided you were unsafe to refer. And that decision usually happens inside the meeting. And you never hear the no, you hear, we'll be in touch. And I call this silent rejection. Most agents think they're building rapport in those meetings, and attorneys are running a quiet evaluation to see whether you understand how probate cases actually work and whether referring you creates risk for them. In this video, I'm going to show you exactly how that evaluation works, what attorneys are listening for, and why most realtors operate in ways that create liability exposure they can't see. Most probate training tells you to buy data, call heirs, mail letters, and then compete with dozens of other agents. And that approach doesn't fail because you're bad at it. It fails because it completely ignores how attorneys think. And attorneys are not looking for marketing help. They're not looking for someone hungry. They're not impressed by your production numbers. They're asking one question. If I refer this realtor, does my risk go up or down? And if you don't understand how to answer that question, you'll never get referred, no matter how good you are at real estate. Here's what most agents never realize. Attorneys don't evaluate you based on what you say you can do. They evaluate you based on whether you understand the sequence of the case and the risk at each step. They're listening for, do you know what has to happen before the next step can begin? Do you know where things typically break? And do you understand what exposes them legally even after the sale closes? And that evaluation is quiet. If you fail at it, you're out, politely, permanently, and without feedback. My name is Curtis McDaniel. My background isn't traditional real estate. I spent 15 years building zero failure systems in aerospace and semiconductors, environments where skipping steps isn't an option. I later moved into legal operations as a director of training and development at a national law firm, where in 1 year, I more than doubled case volume from 8 million to 20 million per month by engineering intake and workflow systems that close the loop between business development and legal operations in a high liability environment. What I do now is apply that same operational discipline to probate through Probate Executive. So when I say attorneys are evaluating you in ways you can't see, I'm not guessing. I've built those systems on their side of the table, and I've seen exactly where realtors create exposure without knowing it. Here's the framework attorneys use, whether they articulate it or not. The real estate portion of every probate case moves through 4 operational phases. And when you sit across from an attorney, they're listening to see whether you understand what has to happen in each phase and in the correct order. And knowing the phases isn't the same as being able to operate inside them with documentation that survives scrutiny. And if you can't demonstrate procedural fluency, you're filtered out before the meeting ends. Let's walk through them. Phase 1, the foundation, getting the property ready. This is where most agents lose attorney trust immediately. Before anything can be listed, title issues must be identified, the property must be secured, the probate referee must complete the appraisal, occupancy issues must be resolved, and repair decisions may require court approval. Attorneys are listening for questions like, can you coordinate with the referee? Do you understand when bids need approval? Do you know what can happen yet and why? And if you talk about marketing before these items are handled, you've already signaled that you don't understand the case. Here's the most common mistake. You start arranging property prep, contractors, repairs, staging, and you handle it informally. Hey, I found a guy for the roof. Can I send him over? And that creates 2 problems. First, you're directing estate decisions without documented authority, which creates decision-making gaps that expose the attorney when someone challenges what happened 3 years later. Second, there's no documentation trail, which means the attorney has nothing to defend with when beneficiaries question who authorized what. Most realtors operate on text messages, verbal approvals, and handshake agreements, and that works fine until someone questions who authorized what. The solution is documented multi-party approval. You arrange the options. The personal representative approves their choice. The attorney reviews before work begins. The system won't let you proceed until all approvals are documented. That creates a record that proves the agent offered options, not decisions. The PR made the choice, not the agent, and the attorney approved the action before money moved. That's the difference between I think I did this right, and here's the documented proof. Most realtors think phase one is about getting the property ready to list. Attorneys see it as, does this realtor understand fiduciary authority, or are they going to create documentation gaps that I'll have to defend in court? And if phase one isn't clean, nothing else matters. Phase two, listing and managing offers. This is not just putting it on the MLS. Depending on the case, this may involve notice of proposed action, mandatory waiting periods, overbid procedures, court confirmation hearings. And attorneys are listening for one thing here. Do you know how to protect the estate while offers are being evaluated? Most agents have never dealt with these requirements, and it shows immediately. Here's what separates operators from transaction coordinators. You don't just present offers, you frame them as decision requests that account for procedural timelines and exposure to the estate. We have 3 offers. Here's how each one impacts the estate's position. Option A closes fastest but requires court confirmation. Option B is all cash but below appraised value. Option C is strongest financially, but extends the timeline 30 days. What's your instruction? That's not sales language, that's operator language, and attorneys hear the difference instantly. Phase 3, final valuation and market launch. This phase isn't about escrow logistics, it's about defensibility. And attorneys care about clear decision records, clean contingency handling, accurate preliminary and final numbers, documentation that survives scrutiny later. They're asking, if this closing gets questioned 6 months from now, can we defend every decision? And here's where the difference becomes visible. Every decision during escrow, price reductions, repair credits, deadline extensions, either gets documented with approval trails or it doesn't. Most realtors handle these decisions informally. Phone calls, text messages, quick agreements. But when someone challenges a decision years later, informal doesn't hold up. And the system logs who requested what options were presented when approvals were given, and creates a chain of custody that attorneys can defend. And if you don't understand that, you're a liability, even if the deal closes smoothly. Most realtors don't even know this phase exists. Phase 4, final accountability, finishing clean. And it's the reason you close a probate sale, think everything went great, and never get another referral from that attorney. Here's what most agents believe. The case ends at close of escrow. Here's what most attorneys know. The case doesn't end at close of escrow. Attorneys are still exposed if contractors weren't paid properly, documents weren't returned, vendors dispute invoices, records are incomplete. This is where attorneys get blamed even when the sale went fine. Here's what happens. 6 months after close, a contractor files a lien claim. 2 years after close, a beneficiary discovers an expense they think was unauthorized. 3 to 5 years after close, someone challenges the final accounting, and the attorney has to reconstruct what decisions were made and by whom. If you operated on text messages, handshake approvals, that attorney has nothing to defend with. But if every expense, every vendor payment, every authorization was documented with proper approval trails, that attorney can pull up proof. 3 bids were presented. The PR selected option 2. The attorney reviewed before work began. The payment was released after completion. That's not a realtor being careful. That's court defensible documentation that eliminates the he said, she said that destroys cases years later. And the realtors who get referred again are the ones who close the loop, deliver clean records, and leave nothing unresolved. This phase is invisible to most agents and critical to attorneys. Now, here's why this matters. Attorneys don't refer based on charm. They refer based on risk reduction. If you demonstrate that you understand sequence, documentation, exposure, cleanup, you become safe to refer. If you don't, you're silently rejected, no matter how polished your pitch was. That's why chasing heirs keeps agents stuck, and why attorney partnerships require a completely different operating system. Not just different tactics, a different compliance architecture. So here's where you are now. You understand why silent rejection happens, how attorneys evaluate realtors, and the 4 phases they're listening for. The next step isn't just learning this framework. The next step is proving you can execute it under pressure. The Probate Executive Certification includes Case Forge, 12 probate scenarios where you'll identify the risks attorneys care about. Edge cases you won't see for years in real practice. Probate Nexus Lab, a complete case simulation from listing to close. You'll manage jobs, financial records, and documentation while an instructor reviews every decision you make. Operational certification, proving you can execute the 4-phase framework under supervision, not just understand it. This is not a course about what to do. It's supervised practice in a controlled environment. The readiness review evaluates whether your market has the case volume to justify this investment, whether you're ready to operate at the standard attorneys can defend in court. Some agents aren't ready yet, and some markets don't justify this level of precision. Some agents are exactly where they need to be, and the readiness review tells you which category you're in. If you're ready, I'll walk you through how the certification eliminates the competence gaps that keeps most realtors locked out of attorney referrals. This is for realtors who want to be operationally certified, not just trained, not just experienced, but proven under supervised practice. Book your readiness review below. I'll see you on the call.